And do you want me to explain why?
Yes.
So imagine that you're charged with burglary and robbery, not you, but somebody is breaking into somebody's house, having a gun, demanding money. One of the people in the house runs upstairs, gets a gun out of the bedroom, comes down the stairs, sees this perpetrator who is believed to be Mr. Hubbard holding a gun, so the resident starts shooting at Mr. Hubbard. Mr. Hubbard gets...
I think appellate attorneys lose their audience, which is the court, when all you say is, witness X testified as follows. Witness Y testified as follows. Witness Z testified as follows. That is so boring, and it is so unimaginative that if I'm in an appellate court and I'm reading that, it's not something that's piquing my interest. So I try to humanize all of the characters that I'm writing about and get away from the fact that you're reviewing a trial transcript.
We're here today to discuss making and preserving a record in criminal cases so that you can appeal. And so we're going to be discussing criminal law appeals, but the focus is going to be on how to handle the district court case for the purpose of making sure that you actually have strong issues in your appeal. Joining me today, I have with us Chief Judge Michael Gibbons of the Nevada Court of Appeals. He is one of the longest serving judges in Nevada with over 27 years of trial and appellate judicial experience. He presided over hundreds of trials in the district court in 4 different counties, and he's heard more than 6,000 appeals as an appellate judge. Prior to becoming a judge, he was a deputy and chief deputy district attorney in Douglas County for over 13 years, handling many high-profile criminal cases, including as the co-prosecutor in the extortion bombing of Harvey's Hotel Casino in Lake Tahoe. Also with me, I have Amy Porray. She's an attorney at McFarling Law Group and the lead attorney for their criminal division, LV Criminal Attorney. She handles criminal defense cases in district court and on appeal. Amy attended UNLV Boyd School of Law, where she graduated summa cum laude. She has worked as a senior law clerk for Chief Justice Robert Rose at the Nevada Supreme Court, as a public defender at the Clark County Public Defender's Office, and in private practice handling family law and criminal defense cases, both in district court and on appeal. And in addition to that, she's worked as an adjunct faculty member at Boyd and taught philosophy at CSN. On Zoom with us as well, we have John Reese Petty, who is a chief deputy in the Washoe County Public Defender's Office. He served as a trial deputy from 1985 to 1987, and since 1994 has managed the appellate division. In between these two positions, John served as the first discovery commissioner for the 2nd Judicial District Court. As an appellate attorney, John primarily represents criminal defendants in direct appeals to the Nevada Supreme Court and the Nevada Court of Appeals. He also handles writ proceedings in both courts. Starting out, Judge Gibbons, what is the importance of preserving the trial record for appeal?
Oh, that's a very good question, Emily. We're off to an important start here today. How many of you have seen a person on television following a trial where the individual was found guilty, and then they proclaim, I am going to appeal and prove my innocence? Well, that's not what happens on appeal. An appellate court doesn't decide if somebody is guilty or not guilty. Rather, the appellate court decides if somebody received a fair trial. That's a common misconception with the public. And so the trial court, the jury, determines if somebody is guilty or not guilty. So it's very important to have a fair trial. It's critical that our system of justice depends upon that. And a way to ensure that there's a fair trial is that there's a defense lawyer who is making objections to ensure that the proper evidence is submitted, the proper procedures are followed, and that the judge is making the correct rulings. So that's what the appellate process is about, and it's dependent upon the trial lawyers and the trial judge to make sure we have the record, because we're not going to hear from the witnesses. We're going to read transcripts of what happened. Sometimes look at videos too, as you know, in family court. But that's where we start.
And Amy, when do you start preserving the record?
The record gets preserved when the defendant makes their first appearance in court following the arrest. So that's when the record starts getting made. Every hearing in a criminal case, no matter how small, has importance and can ultimately affect what happens on the appeal. So for the practitioner to be careful and to protect your client's rights, regardless of whether you think that the case could, should, or will negotiate, you should always look toward assuming it's going to go to trial and ultimately be on appeal, and make sure that all through the handling of the case, you are looking toward preserving that record.
And John, what are your ethical and legal obligations regarding which decisions to appeal?
Thank you. And before I begin, I'm going to say that I completely agree with Amy, particularly with regards to, as you prepare the case, even if you think the case is going to negotiate and settle by way of negotiations, you have to protect that record. Because one, you may be wrong, and two, you may actually have to appeal from that guilty plea. In 1994, the Nevada Supreme Court, in a case called Lozada v. State, ruled that a trial attorney has an absolute duty to appeal from a conviction if a client expresses dissatisfaction with the conviction or otherwise asks for an appeal. And that duty extends not just to the trial arena, but also to guilty pleas, no contest pleas, guilty but mentally ill. And so even if you look at your sentencing transcript and you think, I don't have a single meritorious issue here, the Supreme Court has said, you have a duty to perfect that appeal. And if you don't perfect that appeal, it can lead to claims of ineffective assistance of counsel. I'll add that in 1997, the Supreme Court did away with so-called Anders briefs, where individuals would simply file an affidavit with the court saying that I've reviewed the record, there's no issues here, but the client still wishes to appeal. So here, court, you take a look at it. In a case called Ramos v. State, the court said, we're not going to approve that practice anymore. And now appellate counsel has to do a search of the record, a searching inquiry of the record to determine if there's any issues and raise any issues that present themselves on the record that you have. So your ethical duties are to make sure, one, that you perfect the appeal that your client wants, two, that you review the record carefully so that you can write issues that need to be before the court or at least present themselves in the record. And then finally, sort of the other side of the coin, you have an ethical duty to talk to your client about the pros and cons of an appeal. And this is from Lozada as well. And that includes, if you believe that there are meritorious issues that should be raised on appeal, but the client does not want to appeal, you have to abide by the wishes of the client. So if the client does not wish to appeal, you have to forego it. If a client wishes to appeal, but you think it's not a great idea, you still have to perfect the appeal.
Judge Gibbons, what's the effect if an attorney decides not to appeal a case or doesn't appeal a case when the client has asked to appeal?
Not a good situation for the attorney, as John's just explained. It's called appeal deprivation, and it's a serious allegation. Normally, an appeal from district court to the Supreme Court has to be filed within 30 days after the proceedings are concluded. In a criminal case, a judgment of conviction would be the document that would be filed that would trigger the time period. And if it's not filed, the person, within that time, the person has waived their right to appeal. So no matter what went wrong in that trial, the Supreme Court doesn't have jurisdiction to hear it. So it's very serious. However, there is another avenue for a person who wants to appeal their conviction, and that's called a petition for post-conviction relief or habeas corpus. And in that, if such a petition is filed, the individual can claim that they asked for an appeal and the attorney failed to do it. And if the trial court believes that's true, then the court can allow for the appeal to move forward, even though the time has passed. So there is a remedy for it. But typically you have to file, a criminal defendant would have to file the petition within 1 year of the judgment of conviction. So I'm sure, John, you've seen this claim before too yourself, appeal deprivation. And is there anything that I've explained on that needs clarification from your point of view?
No, Judge, I think that you've explained it very well. I am happy to say that my office has never experienced an appeal deprivation claim. I have a rule with my trial deputies that if a client wants to appeal, please give me a copy of the judgment and a short memo if you have time to tell me about potential issues, and I'll take care of it. So in the Washington County Public Defender's Office, to my knowledge, we've managed to perfect all the appeals that have been requested by clients.
And just to follow up on that, let's say the district court determined that the lawyer, the client didn't ask for an appeal. So that's why the lawyer didn't file it, or it didn't otherwise meet the criteria. Well, that decision can still be appealed. So the Supreme Court can review, or the Court of Appeals, the issue of whether the district court was correct in determining whether the former defendant client was deprived of an appeal. So that's itself is appealable, and we've occasionally see those cases. And I think what John's referring to, and I don't know if you've ever seen this, Amy, but the lawyer gets called into court and has to explain what the conversations were after the decision. And typically you have attorney-client privilege and you can't talk about it, but when the client is making an allegation against the attorney, then that privilege normally goes away. Have you seen that come up before?
Oh, I have. So luckily, fortunately, in my career, I have not had to do a post-conviction hearing myself. I have done post-conviction work as far as bringing post-conviction petitions, but from trials that I've done, I haven't had to testify, but yeah, it is an uncomfortable spot. However, I do think that attorneys should take the position that if something they've done affords the client relief in some way, that's the process and there it should be.
So many times this is months, even years later. Would the attorney have notes about what was discussed after the trial proceedings and about whether an appeal should go forward?
In my practice, I do have notes. I would
The
say
same is
that.
true here. The same is true here. We make sure that those conversations are documented. In particular, if the conversation is, I do not want to appeal, we make sure that is documented, because every once in a while, that person who told you they don't want to appeal and now suddenly wants to appeal, then of course the claim is that you didn't do that which they asked. So we document that information in our files.
And that extends, and I think John would agree, to situations even where we're talking about probation revocation hearings, other things not just extending to trial, but when you have situations where the defendant is entitled to other types of appeal, I keep meticulous notes of that just for that situation.
Yeah, because you can imagine if you're the client defendant, it's your one case. You're going to think you remember everything that happened because it's the most important thing in your life at that moment. As the attorney, you have many cases.
So does this post-conviction relief or deprivation of appeal, does it apply to anything other than guilty verdicts?
It applies to all sorts of situations. A post-conviction relief applies to, it can apply to guilty pleas. Do you want to?
Yeah, I mean, think about the other one that's very common is the sentence that was received, because a person might go in front of the court for sentencing, ask for probation, and the judge sends them to prison. And the attorney then, the client then says to the attorney, I don't like what just happened there. I should have gotten probation. This isn't right. But he never utters the word appeal. So if the client expresses dissatisfaction with what happened, then the lawyer is supposed to interpret that to mean, I want an appeal, even though those words weren't uttered. Have you seen that too, John?
No, I agree with you. And if I was standing next to a client who was dissatisfied with the ruling by the trial court, I'm expecting probation, but I get a prison sentence, and I express my frustration however it is expressed, and the language in Lozada is pretty broad, I would think that triggers in with the trial attorney an obligation to say, listen, I know you're upset. Let me talk to you about your appellate rights, and let's talk about the pros and cons. I mean, if I am in court with a client, I'm going to want to make sure that I have a conversation with that client before the authorities take the client and down to the NNCC or the Nevada Department of Corrections.
Oh,
So
that's a little practical problem. What if your client is removed from the county jail and sent to a state prison, maybe in a different part of the state? So you better, like John said, don't you find out really fast? Do you see that in civil cases too, Emily? I mean, not they're going to jail, but that the client is dissatisfied in some fashion, and then maybe he's even mad at the lawyer, and the communication breaks down. You know, I mean, what do? Do you file an appeal in a civil case too in that
that's
scenario?
interesting. I mean, it sounds like to me that these criminal cases have a very different standard for what has to happen when an attorney is standing next to a criminal defendant who just had a result that they're dissatisfied with. They have a proactive obligation to appeal the case, or they might get hauled into court way in the future to have to defend the decision not to appeal. That's a very unique situation.
So definite contrast to civil cases then.
There are things, and I know John will agree, there are cases, and I know that in my career, there are cases that I have that I may look at again 10 years from now that may still be processing on some sort of relief. Just because I don't know it now, it may come up later because of the multiple levels of post-conviction review at every different way.
Amy, does pretrial motion practice really matter?
Yes, pretrial motion practice. That was a quick yes. Very quick yes. Yes, it absolutely does. And the Ninth Circuit has observed that the purpose of a pretrial motion is to avoid cluttering up the trial and reducing the need for sidebar conferences and arguments outside the presence of the jury. That's the legal standard. The practical effect is that you are preserving that record with pretrial motion practice. And this can be whether you're doing motions in limine, and I know that we're gonna go into depth, can go into depth in that just in a minute, but talking about motions in limine, suppression motions, when we're doing either suppressing physical evidence, or if your client has given a statement, and you're going to want to absolutely file a motion, it's called Jackson versus Deno, to get a hearing. You want to get hearings on these so that the court has something to review when determining whether it should be suppressed or not, and to determine whether it should be admissible at trial.
Is there a case that really highlights this issue of the importance of preserving your record at pretrial hearings?
So that case is Richmond versus State, and I think John can probably talk about that. He's got some excellent familiarity with it.
What I would say is that, you know, to answer the question that you posed, Amy, does pretrial motion practice really matter? Absolutely, for the reasons that Amy mentioned, as outlined by the Ninth Circuit, but also just from the standpoint of the practitioner. If you've made pretrial motions and gotten rulings from the court, that gives you an idea of what to expect at trial, and it's much more comforting to go into trial knowing what to expect and to be surprised. So those pretrial rulings are really important. The thing I think that in the case that Amy mentioned, Richmond v. State, that's an important case because before it was decided, the general, and this is the general rule, that motions in limine are sort of advisory. They sort of give you an indication of how the court might rule if at the time during trial the evidence is offered, what you can expect. As a consequence, for a long time, if you didn't object at the time the evidence was admitted at trial, you waived that objection or you forfeited that issue, even though you might have been successful on the motion in limine. But in Richmond v. State, the Supreme Court decided that if the trial judge in a motion hearing makes a definitive ruling, so you know absolutely that the evidence is coming in, and it's not evidence that you want, it's something that you're objecting to, and you've challenged that evidence by way of a motion in limine. At trial, you don't have to object again just to preserve the issue. The issue is preserved by virtue of your motion. I think, though, and I think Judge Gibbons will agree with me, I think, though, that if you are a practitioner and you're just a little concerned about whether or not you're going to preserve that issue, you should go ahead and make your objection, but do it outside the presence of the jury. Ask for the judge to instruct the state, for example, to give a heads up when they're going to call the witness that they intend to use to get this evidence before the jury, so that the objection can be restated on the record and preserved, just as a cautionary matter. Of course, the other side of the coin is if the court has made a ruling that certain evidence is not going to be admitted at trial, and yet during the course of trial, the opposing party seeks to get it in anyway, then I think counsel has to object. And I think they would be foolish not to object in order to alert the judge that that opposing counsel is in violation of the court's order and is trying to introduce evidence that has been ruled judicially inadmissible. So I think those are some of the caveats with regards to motions in limine. Motions to suppress is a different animal. If you get you almost always will get a definitive ruling on a motion to suppress, and so you preserve that by virtue of the pretrial practice.
One thing I wanted to add on that, John, too, that I was is that when you have a situation with your pretrial motion in limine, and John was talking about, then you have the opposing party violating something that the court had done, follow that through with moving for a mistrial. And I think that would then preserve, and Judge Gibbons, tell me if you're right, then preserve your record fully for review. Because if your mistrial is not granted, then you have this very strong level of review on appeal.
Right. Amy, that's an excellent point. So if it's anything significant, yes, you would move for a mistrial. And then that also opens the door for a motions following trial, like a motion for a new trial too, even before you filed an appeal.
Now, are decisions on pretrial motions appealable?
No, they would, no, they're not. They're not appealable.
Do you mean right then
Right.
or later on?
So that's why I was kind of not on an interlocutory basis, and not by the defense, I'll say. And so panel number 2 that we're doing, give a little teaser that the state may have some interlocutory rights, but for the defense, under its NRS 177.045, any of the pretrial rulings may be reviewable by the appellate court.
And so that would be when you file an appeal after the final verdict in the case?
Yes. Mm-hmm.
Right, if I could add to that, Emily. So to follow up on what John and Amy were both saying, so before trial you file this motion in limine, which is just a fancy way of saying, Judge, look at the evidence before the trial and let us know if it's admissible. And that way everybody can prepare for trial knowing what evidence will be coming in. And if it's somehow the evidence is submitted outside the scope of what the judge says, then all these other issues come up that Amy was talking about. But on appeal, if you take this to the next step, the court on appeal, the appellate court, looks at what was the objection below. So we'll read this motion in limine and see how they frame the argument. Now, are they making a different argument on appeal? Because if you challenge certain evidence and you give a reason, like you say it was an illegal search because the warrant was too broad, just as an example. And then on appeal, you argue something else. It was an illegal search because they shouldn't have opened a container. It's a different argument, or there's a different legal reason given for it. And that was not preserved because that wasn't the objection made below. So just as a practice pointer, everybody looks at their case before trial, but by the time you get into trial, the situation can often change. So it's wise to raise your objection again so you've preserved it, and you possibly can even expand it and give all reasons. So you think of things during trial that you might not have thought of before trial. And so give your reason then, because I can assure you the appellate court is going to be looking to see if you've changed what you said to the judge. Is it fair to the trial judge to have you make a certain objection in front of that person and then you argue a different objection on appeal? The trial court should have the chance to address it first. So you will be held to a higher standard on appeal if you didn't make that same objection below.
Is there a case that had this issue come up in it?
Well, I've seen it come up many times. I mean, we were discussing before we got here the Hubbard case. Is that the one you're referring to? So in this case, it wasn't so much that it was a different objection, but in the pretrial proceeding, the state offered evidence that Mr. Hubbard had been convicted of burglary a year before in Washington State. And they offered the court records from the Washington proceedings to show he'd been convicted. And the trial judge said, I'm going to allow that to be admitted, even though it's a different crime, it's an uncharged crime, but under the state's theory, it could help prove intent because he was charged with burglary and robbery on the case in Las Vegas. So you have the Washington case and you have the Las Vegas case. Normally, you can't have evidence from another case brought up in the current case. That's considered unfair that the jury might convict somebody because they're a bad person rather than there was sufficient proof they committed the new crime. So at any rate, the trial judge said, all right, I'm going to allow this, but I'm going to monitor it closely as it comes out in trial. And Mr. District Attorney, if it is presented the way you said, then I'm going to allow it. Well, at the trial, the state, through the district attorney, offered the evidence in a different fashion. They brought in the victim from the Washington State burglary. And however, the objection wasn't made that the manner of presentation of the evidence was different at the trial than from the pretrial hearing. So that wasn't much of an issue on that appeal because it was clearly should not have been allowed at all. And do you want me to explain why?
Yes.
So imagine that you're charged with burglary and robbery, not you, but somebody is breaking into somebody's house, having a gun, demanding money. One of the people in the house runs upstairs, gets a gun out of the bedroom, comes down the stairs, sees this perpetrator who was believed to be Mr. Hubbard holding a gun, so the resident starts shooting at Mr. Hubbard. Mr. Hubbard gets hit by a bullet in the shoulder. He runs out of the house. He leaves the other people behind. He's walking down the street. The police are called. He goes into a convenience store and the police show up. And the police ask him, what are you doing and why were you shot? And he said, well, somebody tried to rob me over a drug deal. And, well, were you at this house where this robbery just happened? Oh, no, I wasn't there. I was just walking down the street. So his defense in the case is not that he did not have intent to commit robbery in the house in Las Vegas. His intent was, it wasn't me, you got the wrong guy. And so why would the state bring up evidence of a burglary from the year before to prove he intended to commit a burglary in Las Vegas the next year? I mean, the two didn't tie together. So at any rate, that's what happened in that case, and both the Court of Appeals in a split decision and the Nevada Supreme Court in a split decision said that the prior burglary should not have been allowed into evidence. So if the pretrial hearing had been a little more thorough, if everybody had developed these arguments, perhaps the correct ruling would have been made at the pretrial hearing rather than the incorrect admission of the evidence at trial and then an appeal to two different courts. So it shows you the importance of getting it right the first time pretrial.
So, Amy, what are some things that can be done to help preserve the record for an appeal?
So are you talking about so I'm going to talk about what I do at trial, I guess, in that way. And so I'm going to kind of dovetail on talking about Hubbard and things that I do to help prepare for that type of a situation. I look at trial preparation as being kind of twofold. I'm preparing to cross-examine witnesses, present my theory, prepare my opening, my closing, but I'm also getting ready for every possible objection I can. What objections am I going to make? What record am I going to make? What can I anticipate going wrong? So in that situation, and I'm not saying by any means perfect, I have the benefit of looking at the playbook, but I would say that you take that and you go, okay, so we have this coming in for this purpose. Let's make sure it gets introduced for this purpose. Keep an eye on those things. One thing that I do when I go to trial is I bring a trial notebook. It's somewhat of a trial, I call it my trial appellate notebook, and it walks me through the trial from beginning to end with every what I have come up with being possible evidentiary preservation type appellate issue, beginning with voir dire. So I have in there, I have Batson, the entire case of Batson, as well as it tells me how my notes, here's how to make a Batson objection. Here's the procedure I must follow when I pick a jury and I want to make this challenge, because there's an absolute specific procedure that must be followed if I'm going to preserve that objection. And if I don't do it right, I lose that issue on appeal if there is an issue. It's very clear, it's very specific. My notebook also has any other voir dire type issues. And so then it moves me through any objections I may have in opening. I have a list of any evidentiary objections, hearsay, the statutes.
Amy, you think maybe it'd be explain a little more about Batson, because most people don't know what that case is.
Oh.
So if you're picking a jury and there's a right to have a cross-section of the community in the jury, and if the district attorney excludes a juror based upon race, gender, or other factors, that's improper. And so how would you make the objection in that situation?
So if then you have to, if the district attorney excludes a juror, then you have to object, and you have to say that they are doing this based on race, gender, et cetera. And then then it goes to the district attorney to say that they are exercising a race-neutral reason, a gender-neutral reason. Then it goes back to you to say that this is mere pretext. And then you have to make a full record. There's a whole shifting that goes around, and you have to make a full record of why their response is not merely pretextual. They're going to say, well, we exercised our challenge against, Ms. Juror X because she said that because she has brown hair, for example, some reason. And then you have to say, well, all other jurors, and go through your notes meticulously to find out why their answer is mere pretext. And there's a whole set of factors that must be followed pretty much perfectly in order to preserve this objection. And it's so important because when there is a Batson challenge, and that's the case, so that's why I keep saying it for shorthand, but when your client has been denied and there's a Batson objection, and the state has exercised a challenge based on race, gender, any other of the protected groups, then it is a structural error, and it is huge, and it means that your case is automatically subject to reversal.
So you were describing having a notebook before going into trial, so you have all of that at your fingertips in case the issue comes up.
It comes with me to trial. It's something I put together over the years, and I have the same notebook. I've been schlepping it to every trial with me over the years. I have all of the standard objections to closing arguments, and it even though you get to a point where you know these things, If I don't even have to look at it, it's there with me in case I do, in case I have a weird objection. And so then I get into trial, and when the unknown comes up, which it always does, always. I have yet to do a trial where it doesn't, then I'm ready for some of these issues.
I bet the appellate attorney would love you, because you could hand the information right to the appellate lawyer and say, here are my notes, this is exactly what happened. Can you raise this on appeal?
And I do try and keep, you know, I when I was in the public defender's office, I would keep a list as well for the appellate attorneys. If I wasn't going to do my own, then hand it and say, here's what I saw, here's where it is. One other thing that as far as objections, make the objection, approach the bench if that's how, you know, the court wants you to do it. You do your bench conference, preserve your objection, make your objection there, get your ruling, and then you need to actually put it on the record completely, or the court can't review it.
And John, what happens when the appellate attorney gets the record?
Well, there's a few things that take place. So I want to just sort of turn back to what Amy and Judge Gibbons mentioned, and that is what's important to realize about, and this is some advice for the trial attorney, is that the object, if you are upset with a particular piece of evidence and you want to object, please object contemporaneously at the time that it's being offered in order to preserve it. And state your objection. Don't simply say we object. Explain the basis for your objection, because as Judge Gibbons alluded, on appeal, the appellate court is reviewing what the trial court did with regards to the issue that was before the court and the nature of the objection as against a particular piece of evidence that's in question. The appellate court is not seeking to review what the trial court might have done if a different objection had been made. The appellate court simply isn't going to entertain that. So you need to object contemporaneously. You need to state your objection clearly. And there is no prohibition for counsel to state multiple grounds why this evidence shouldn't be admitted. Because it could be the case, and there's a great case called Stevenson versus State, where the Supreme Court reversed, not on the primary objection, which was hearsay with regards to some price tags on an article of clothing, but on a best evidence objection that was sort of thrown in at the last minute. So that best evidence objection actually saved the day, and they got a new trial based on the introduction of evidence that should not have been admitted. Now, going back to your question with regards to what a trial attorney does is you have to scour the record. And when I think of the record, there is, of course, the notes from trial counsel. And if trial counsel and appellate counsel are the same individual, then the beautiful thing is that you have complete knowledge of the record. But if you are an appellate attorney and you were not trial counsel, the benefit there is that you have a fresh set of eyes. They get to look at the record. And the record, from my standpoint, starts with going through the district courts. Like here in Washoe County, we can access the district court's electronic file to determine what motions were filed, what rulings were made, what transcripts are already in the file, what transcripts need to be ordered, such as trial transcripts, for example, or if it's a sentencing appeal, a sentencing transcript, or if it's a probation revocation, the transcript of that probation revocation hearing, and get the notice of appeal filed together with the case appeal statement, together with the request for the transcripts that you need. And in my practice, since we are an institutional defender, we have a right to those transcripts at public expense. So we have to file a motion for transcripts at public expense, and they get a district court order to order those, and then we get those transcripts delivered to us. Primarily, what an appellate attorney does is a lot of reading. You read a lot of the transcripts, you read a lot of case law, you read a lot of statutes and secondary authority in order to frame the arguments that you think the facts that are contained in the record justify. And on that note, before I turn it back to Amy to amplify on this, the appeal is a closed record. An appeal is a review of what took place in the district court. We don't have the option of supplementing the record with information that was not before the district court judge. And we can't argue that if he or she had had this information, the result would have been different. We just simply can't add that information to the record. An appeal is a closed universe. And I will say that is a difficult concept sometimes to explain to clients who want you to explain to the court why whatever happened to them was fundamentally unfair and everything that they're talking about is outside the record. Would you agree?
I would. That was one thing I was going to add as well to that, is explaining to the client what the expectations should be on appeal and what can be considered and what cannot. And that's something, Emily, that is applicable to in our civil appeals when clients want things reviewed and what they want to talk about. It's kind of hard sometimes to explain, well, here, it's a cold record, like you said, and it's closed, and we can't put anything new in. We can't talk about the witnesses were lying because because you said they were, and it's a tough situation to really explain to, especially someone who was just convicted of a crime, that here's where we're at, and they have less control over the decisions that they make in an appeal process. Even criminal defendants are limited to the decisions that they make in a trial case down in the trial court. They're even more limited on appeal.
Now, in family court cases, if I get an appeal before me, someone who wants to appeal a case, and their biggest gripes about the proceedings were that their attorney didn't even offer certain evidence into the record or things like that, the first thing I do is file a motion to reconsider, a motion for new trial, in order to get those that evidence or arguments into the record. Is that something that you can do or that happens in criminal cases?
So we don't typically have any evidence to introduce. We can certainly file a motion for a new trial if there are grounds to do so. It's a whole different situation than what we see with the family appeals and introducing. If there are arguments from a client about what their attorney did or did not do, that's a post-conviction issue, which follows after an appeal. It would be, could they raise right then and there what the trial counsel did do? I suppose they could. It would be a prudent thing to do the appeal first and then the post-conviction after. Certainly a motion for new trial is available, but there has to be a reason for it. And
there's a very short time limit too. I believe
Right.
it's 7 days.
Mm-hmm. Very short.
If I could add to what Amy said, and that is, if the client comes to the appellate attorney and says, my trial attorney didn't do a number of things that I wanted that trial attorney to do, or that trial attorney did some stuff that I did not want to have done, so I think he's ineffective, there may be an argument to be made there, but it won't be on direct appeal, because the Nevada Supreme Court has said claims of ineffective assistance of counsel cannot be raised on a direct appeal from a judgment of conviction. It has to be pursued through a post-conviction. And the reason why is so that a record can be developed on the claims that are being made by the client, and as they might be countered by what trial counsel can explain what happened, what the strategy was, or what the thinking was. I will also add sort of in a different aspect, but one of the things that appellate counsel does, we were talking about pretrial motions. There can be a lot of pretrial motions, but not everything that takes place in a pretrial motion is going to provide fodder for an appeal. Amy and I were talking earlier. I'll give you an example. Let's say you have a Hallmark expert witness hearing in order to establish the qualifications, the assistance, and the scope of that expert's testimony. And the court makes a ruling that the expert is going to testify, and you initially objected to that. That's why you had the hallmark hearing. It very well may be the case that by the time appeal comes around, that issue really isn't a big issue. It might be the case that the expert testified, but the testimony wasn't damaging. It might be the case that notwithstanding the court's order, the expert never testified. Or it could be the case that the expert testified, but you withdrew your objection, you abandoned or forfeited your challenge to it. And as a consequence, there really isn't any issue, any merit in raising that. And then on the more practical matter, it could very well be the case that there are such great issues created at the trial that the expert witness issue just isn't worth pursuing because you're not going to get any relief from it. So appellate counsel has the ability to weed through the record that has been created to determine what issues are best to be presented to the Supreme Court or the Court of Appeal in order to get the relief that you hope you can get for your client.
How do you organize the appellate argument, John?
That is a case-by-case sort of inquiry. How I organize an appellate argument for trial is different than, say, for sentencing appeals. Sentencing appeals, basically, you're reviewing what the district court did under an abuse of discretion. So I'm trying to pull as much out of the sentencing transcript, and some sentencing transcripts are only 10, 15, 20 pages long. So it's you're trying to do the best you can in terms of establishing abuse of discretion on the part of the trial court in order to get a new sentencing hearing for your client. Trial is different. I try to, in terms of putting together the statement of facts, I try to do it in a narrative fashion that makes sense. And there are two things that I strive to avoid. One, I don't do my statement of facts in a sort of sequential fashion with regards to the witnesses that testified at trial. There may be a witness who testified third or fourth or fifth that makes a great opening, provides facts for a great opening, but I'm not going to wait until page 22 to get to that third or fifth witness. I'm going to use that witness right at the beginning because there's a story that I want to tell. There is the story that was told to the trial court, but I want to use those facts in order to tell an appellate story. The other thing that I don't do, and it's just a pet peeve, is I think appellate attorneys lose their audience, which is the court, when all you say is, witness X testified as follows. Witness Y testified as follows. Witness Z testified as follows. That is so boring, and it is so unimaginative that if I'm in an appellate court and I'm reading that, it's not something that's piquing my interest. So I try to humanize all of the characters that I'm writing about and get away from the fact that you're reviewing a trial transcript. You're actually taking into consideration the testimony and the opinions of live witnesses. You're just reading about it.